For our next story, we have the state of California et al. Versus the United States federal government as it relates to the regulation of standards for tailpipe emissions for cars. So the state of California and other states have regulations as it relates to this, and the U.S. federal government has regulations as it relates to this. So one of the questions is whether or not the state of California can regulate in a way that's inconsistent with federal law. So we're going to read the state of California's complaint and see what they say in terms of the Trump administration or other administrations attempting to force all the states to conform to U.S. federal guidelines as it relates to more stringent emissions standards as it relates to cars. So let's get started with this decision. Plaintiff, the states of California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Minnesota, Nevada, New Jersey, New Mexico, New York, North Carolina, Oregon, Rhode Island, Vermont, Washington, and Wisconsin, the Commonwealths of Massachusetts, Pennsylvania, and Virginia, and the people of the state of Michigan, the District of Columbia, and the city of Los Angeles and New York allege as follows. The plaintiffs bring this action for declaratory and injunctive release against final regulations of the National Highway Traffic Safety Administration to be codified in the Code of Federal Regulations and appendices to the parts. The signed register publication versions is attached. The state plaintiffs respectfully request that the regulation be declared unlawful and set aside because it exceeds the federal government's authority, contravenes Congressional intent, and is arbitrary and capricious, and because the NHTSA has failed to conduct the analysis required under the Environmental Protection Policy Analysis. The preemption regulation declared that Federal Energy Policy and Conservation Act of 1975 preempts state law that regulates greenhouse gases from new passenger cars and light trucks. The preemption regulation targets the name of greenhouse gas emissions and zero emissions vehicle standards promulgated by the state of California and adopted by 12 other states. California has had emission standards for light-duty vehicles for 60 years, and California standards at issue are long-standing and fundamental parts of many states' plaintiffs' efforts to protect the public health and welfare in their states, to meet state goals for reduction of harmful air pollution, including greenhouse gas, and to attain or maintain federal air quality standards. Indeed, the California standards are one of the most effective state policies to reduce greenhouse gases and other pollutant emissions from the transportation sector. California standards are projected to result in more than 2 million additional zero-emission vehicles on the road by 2025, and in the absence of existing federal standards to reduce greenhouse gases by more than 66 million metric tons by 2030, greater than the amount emitted by all the power plants in California. The federal government has repeatedly approved several plaintiffs' use of California standards as necessary for a wide variety of purposes. It's granted waivers under the preemption under Section 209 of the Clean Air Act, both for greenhouse gases standards and for zero-emission vehicles. The federal government has also approved these standards as necessary components of several plaintiffs' plans to attain national ambient air quality standards under the Clean Air Act, and has approved state reliance on zero-emission vehicle standards in determining the pollution impact on transportation planning decisions. Moreover, for the last decade, the federal government has harmonized its own greenhouse emission standards and fuel economy standards with California standards. And California has been widely regulating vehicle emissions since 1959. The preemption regulation declares that California's decades-old zero-emission vehicle standards are both related to fuel economy standards and in conflict with them. Preemption regulation, page 50. But the regulation itself demonstrates the opposite. Congress has not authorized NHTSA to set fuel economy standards for vehicles, including zero-emission vehicles that run exclusively on alternative fuels like electricity, and has prohibited the federal government from taking the availability of zero-emission vehicles into account when setting federal fuel standards, meaning that zero-emission vehicles do not affect fuel economy standards. NHTSA proposed the preemption regulation as part of a joint EPA-NHTSA rulemaking package published in the Federal Register. As part of the same package, NHTSA proposed to weaken the existing fuel economy standards for model year 2021 so that it would be no more stringent than the model 2020 level. NHTSA also proposed to set fuel economy standards at the same level for 2022 through 2026. EPA proposed to weaken existing federal standards for model years 2021 through 2026, so they likewise be frozen at model year 2020 levels, and to revoke the California's waiver under the standards that have previously applied. The final preemption regulation was signed by Defendant Owens, the Transportation Secretary, on September the 19th, 2019. The final preemption was not accompanied by any action changing or setting NHTSA economy standards. However, the preemption regulation does appear in the same pre-publication notice. The preemption regulation declares that California standards conflict with national standards, even though automakers have been able to meet California standards by complying with federal greenhouse standards that were issued in the joint rulemaking. And the preamble to the proposed regulations, NHTSA, claims to comply with requirements of Executive Order 13132, which proposes requirements on agencies that promulgate regulations. That order has particular requirements for preemption regulations. Among other things, it requires agencies must consult with states early in the process. And NHTSA did not consult with them early in the process. The preemption regulation is contrary to law because it interprets the statute as expressly and implicitly preempting state laws regulating or prohibiting or having direct or substantial effect of regulating or prohibiting tailpipe greenhouse emissions, regardless of whether the EPA has waived clear act preemption of those laws under Section 209 of the Clean Air Act. The preemption regulation is contrary to law because it conflicts with congressional intent, as recognized by the Supreme Court, to establish two distinct statutory schemes for separate regulation of vehicles and fuel economy. The preemption regulation wrongly interprets Congress's adoption of the statute as implicitly revoking California's authority to set vehicle emission standards, at least with respect to the greenhouse gases. That interpretation is contrary to Congress's direction in the statute that NHTSA consider and give effect to California emission standards. It's also contrary to further congressional action reaffirming and expanding California's authority to set vehicle emission standards that Congress recognized could affect fuel economy, including 1977 amendments to the Clean Air Act and 1994 recodification of the statute. The preemption regulation is also contrary to law because it disregards Congress's express recognition of California's greenhouse gas standards in the statute and Congress's express recognition of California's zero-emission vehicle standards in the 1990 emissions to the Clean Air Act. The preemption regulation violates NHTSA's general conformity obligations under Section 176 of the Clean Air Act to refrain from taking actions that frustrate states' abilities to attain or maintain national ambient air quality standards. By purporting to declare preempted the California standards it previously recognized as necessary for several state plaintiffs to attain or maintain those standards, the NHTSA action will cause increased criteria pollutant levels in ambient air and interfere with state plaintiffs' efforts to attain or maintain those standards. In connection with other foreseeable actions, the preemption regulation will contribute to new violations in non-attainment or maintenance areas in a manner that will increase the frequency or severity of new violations. The preemption regulation is unlawful and arbitrary and capricious because it violates and fails to consider the statute's objectives of conserving energy and promoting development of vehicles powered by less conventional energy sources such as electricity. Preemption regulation is arbitrary and capricious because NHTSA fails to adequately explain how preemption of laws is necessary to maintain federal air quality standards does not interfere with the state's ability to maintain those standards. The federal regulation is arbitrary and capricious because it fails to address or consider state reliance approval by EPA on zero-emission vehicle standards for the purposes of transportation conformity under Section 176. The preemption regulation is unwarranted by the facts because it purports to declare the California standards conflict with congressional objectives for the statute, but the NHTSA has not identified and cannot identify any actual evidence of a conflict, despite the fact that California has had enforceable zero-emission vehicle standards for more than 20 years and greenhouse gas standards for 9 years. So that is the state of California versus the U.S. federal government. So the U.S. federal government, through its proposed rulemaking, has proposed a rule that would, under the U.S. terms, codify and preempt, which is to say that no state can regulate in this area. So all states would be bound by the federal regulation, and no state could regulate more strictly than the federal government standards. So the state of California, which has more stringent regulations, would be unable to have those regulations in place. Now, preemption is something the federal government can generally do to preempt the field, but when it does so, it must do so clearly and unambiguously. It must make it clear that Congress is preempting the field. So the general complaint here is that the Congress has not done so, and in fact, in its legislation has directly indicated that there should not be preemption, and the state of California has a reliance interest on previous waivers granted, and the federal government does not have an interest in not granting those waivers under these regulations. It's particularly where the state of California is trying to meet the federal regulations. So on balance, from the state of California's complaint, I would say the state of California has a legitimate complaint. Now, of course, we have not seen the federal government's response to this yet. We've not seen their argument yet. So we don't know the strength of the federal government argument, but on the face of the complaint brought by the state of California, I would rate their complaint as fairly plausible and states forth a good and well-pled cause of action. Whether or not they're right or not, we'll have to wait for further development, but it seems like a reasonable complaint on its merits. The state of California has some legitimate grievances here, but perhaps the federal government is right and these are preempted. We'd have to get much deeper into the Administrative Procedure Act, and the federal government's argument is going to do that for us in terms of the preemption issues. So I look forward to reading the federal government's response that's going to get into those preemption issues, really get into the meat of the statutes in terms of whether their authority to grant this waiver or not is preempted or not, and we'll see what happens forward. But so far, an interesting complaint. We'll see what happens next.